Actually, what's happened is that the U.S. EPA has made the public statement now that they will begin to follow their legal requirements under the Endangered Species Act, which was passed about 1973. To date, so far, the agency has said they really have not followed the mandates of what ESA requirements are for all federal agencies. Of course, the EPA is the agency responsible for registration of all pesticides that we use here in Illinois in agricultural systems. And so what the agency has said, because of the requirements of ESA to review each individual pesticide, I think they would estimate it would take something like 320 or 360 years. So really, from a feasibility standpoint, they cannot review each of these individual pesticides. So they're trying to come up with some proposals to more or less streamline their obligations under ESA. And so a couple that have been proposed recently for public comment. One is what they call a pilot program to try to protect 27, I believe it is, listed threatened or endangered species. How the agency is actually laying the groundwork, so to speak, that specifically is going to provide additional protections for these listed species. There's quite a bit of difference in what the agency is proposing. Here in Illinois, of those 27, we have actually two here in Illinois, a plant species called Mead's milkweed and an insect called the rusty patch bumblebee. Now, the proposals from the agency on the Mead's milkweed are not, I would not consider them terribly onerous in terms of what agricultural producers will have to contend with. But what the agency has proposed for the rusty patch bumblebee is what they refer to as a pesticide use limitation area or exclusion zone. And the agency has said for that particular species, they're proposing that no pesticides can be used in the native range of that bumblebee species. And their own estimates are that that will impact approximately 1 million acres in the states of Illinois, Wisconsin, and Minnesota, where pesticide use may actually be completely prohibited in that area. So no insecticide applications, no fungicide applications, no herbicide applications. The other one that came out just last week is the agency's proposal to try to work through different classes of pesticides. This first one that they've actually released now is what they call their herbicide plan. How the agency will handle off-target movement of herbicides specifically, given the fact that of the roughly 1,700 species listed as either endangered or threatened, over half of these are plant species. And so obviously the agency is concerned with the direct effect of herbicides either on these plant species, but there's also the stipulation under the Endangered Species Act that you cannot harm the species itself, but also you have to be able to protect and maintain that species' critical habitat. So for example, we may be dealing with, for example, an endangered mammal species, an endangered insect species, whereas a herbicide may not have a direct effect on that species per se, but yet off-target movement could affect any of the plant species that that individual endangered species would consider or use as a, for example, a food source, as a shelter for us, and that would constitute its critical habitat.
It sounds like farmers could be severely impacted by this whole effort.
There's actually been changes that have taken place under the ESA on several pesticide product labels right now. And for example, the one that we use a lot of times when we have this conversation with either farmers or custom applicators, we highlight the changes that took place a year and a half ago with the Enlist 1 and the Enlist Duo labels. The changes that occurred when these labels were renewed for 7 years include what the agency calls runoff mitigation practices. And so if you read these new revised labels, if we make an application of, say, either Enlist 1 or Enlist Duo, there are additional requirements now that an applicator, a farmer, a landowner would have to implement in order to meet a minimum number of what they refer to as points. So for example, you either have to do practices that accumulate 4 additional points or 6 additional points based on the hydrologic group of the soil in which that application was made. So for example, for many of the soils here in the Champaign-Urbana area, if we would make an application of Enlist 1 on Enlist soybean, for example, farmers would have to implement practices that total 6 additional points. Now, those are defined on the label, what these practices are and their point value. But to date, it's been very difficult to find a lot of either farmers or people in the retail sector that are even aware some of these changes have taken place. So as we move forward thinking about how ESA is going to impact what we do on a daily basis in production agriculture, these changes have come already. And there will be more changes on more product labels moving forward.
Seems like this would be not only difficult for individual farmers, but really tough on the commercial applicator industry, and particularly on crop sprayers that right now are in the air.
It's difficult in a lot of different respects. For example, if you look at these requirements now on some of these labels, it specifies, that these are things that the applicator and or landowner have to do. Well, one unique feature, so to speak, of Illinois agriculture is that a very high percentage of our acres are not actually treated by the individual farmer. They hire this out from a retail applicator. This is the person who shows up with the rig with the right appropriate pesticide in the tank and makes this application according to the needs of whether it's a herbicide, insecticide, or fungicide to meet the label requirements. But this is the person that cannot mandate that field needs to have a 100-foot wide grassway at the downslope side. This is not the person who can go to the farmer in January and say, if you want this pesticide applied, that you have to do no-till this year. So there's a lot of uncertainty, I guess, in my mind that it remains unresolved is exactly who is responsible for implementing some of these new label requirements, because I think the agency has looked at these practices, but yet from a feasibility standpoint, there still remains a lot of unanswered questions about who has the authority to mandate these, and then who has the responsibility, so to speak, to implement them.
EPA, in its proposal here, is overtly seeking farmer input. Farmers can make comments and all of this. How should farmers approach this opportunity to provide their feedback?
All of these proposals that the agency has put forward, they put these forward in the government documents, and these are open for different periods of time for public comment. And if there's ever been a time where we would encourage farmers to become more involved in this process, we highly encourage all farmers, we encourage all custom applicators in the state to look at what these proposals are from the agency. These are now open for public comment. And we would certainly encourage people to take the time to become aware of what some of these proposals are. Think about how they can impact your individual operation. I guess in a sort of a catchphrase way to think about this, it's very likely that these proposals will impact every pesticide application that we make in this state in the very near future. And so farmers, applicators really need to have a voice in how some of these practices are going to be implemented, whether or not these things are actually feasible. But yet one thing that I know the agency is very interested in hearing from the boots on the ground individuals, are there other practices that maybe the agency should consider as anything that could reduce either physical spray drift or movement of an applied pesticide off of a treated area, a treated field? They're very open to those comments. They're very open to these other additional suggestions. If somebody's just making a comment to the agency, well, these things, we can't do these things, these are all silly, it's just going to be a burden to us, those are really comments that are not really constructive for the agency to look at. They're looking for this feedback, they're looking for this input that comes from those individuals who are going to be directly affected by these label changes.